My lord, this matter relates to that Justice Raghuveer Das commission relating to missing of the Ratnabundar keys. I prayed for publication of all those things. It was pending for the last 5 years. It was constituted on 4th of April, 6th of June, and submitted its report on 29th of November 2018. Since last year, it's pending.
No, has it been tabled in the assembly?
Yes, but pending, I don't understand. It has to be tabled before the assembly,
Yes.
and so
There is a procedure, my lords. I prayed for following that procedure.
that procedure must have been followed.
No, it
But
is
you
not followed.
better find out, sir.
Yes. How can you know that?
No, recently
It is
there is
not
a, my
thing
lord,
to be
recently
publicized.
there is a statement in the legislator that it's not getting published for the last 5 years from the opposition.
But why have
Even
you
after-
made so many people parties? It's only the state government who should make a party. All the others are not necessary at this stage.
Because I have mentioned those party in case.
For what?
In
They have
case-
nothing to do with tabling the report or publishing it.
Yes, it's a law commission.
No, but
law
they have
report.
nothing to do except state of Orissa. The others like archaeological survey and all, how are they
My
concerned?
lord, can you see the prayer? Because of this non-publication of this report, they are not handling over that Ratnabundar for repair.
We don't know that.
Yes, it is. It is a
It's
fact.
already a matter on this Ratna Mandap, no? Mr. Monti?
That is a mother
That
of.
the other Mr. Monti,
Yes.
former engineer, he's the amicus curiae.
He was
my lord.
appearing.
When is that coming up? Anyway, you find out
That
about
is done
this.
in July, I guess.
You
That-
say we'll right now confined to,
Opposite pen number 1.
prayer number 1. Notice is issued to the state of Orissa, bracket opposite parties 1 and 2, and 8, to apprise the court of the current status of the report submitted by the Justice Raghuveer Das Commission,
Yes, my lord.
constituted under the Commissions of Inquiry Act, 1952. The affidavit be filed not later than 1st July 2023. List on 10th July.
Item number 2.
My lord, in item number 2, I'm appearing in person. This is about opening of a sleep disorder clinic in SCB Medical College. Incidentally, that clinic was operating from 2013 to 2017. Thereafter, it has been closed and all the equipments are lying unused. And more importantly, my lord, sleep disorder, even I was not aware, has gone up by 20% after this pandemic. And it leads to a lot of problems amongst young adults nowadays. So there is a lot of necessity of this kind of a sleep disorder clinic. So if your lordship could...
But you've not submitted any representation, nothing.
Representation, yes, my lords.
You've send a letter to Chief Minister.
Yes, ma'am, with copies to DMET because it's a policy decision. So I thought maybe DMET and Health Secretary and all.
Can we ask the DMET to...
Yes.
It appears that on the issue of closure of the sleep disorder clinics, which were earlier functioning in the SCB Medical College, the petitioner, who is a practicing advocate, had made a representation way back on 15th October 2022. With copies to the Director of Medical Education and Training, Odisha Bhubaneswar, as well as the Superintendent of the SCB Medical College and Hospital. Full stop. The petitioner appearing in person says that she has not heard. She has had no response till date. Paragraph. The Director of Medical Education and Training, Odisha, will examine the petitioner's request, bracket annexure 1, and after hearing her on a date to be communicated to her at least 1 week in advance, take a decision on the issue and communicate it to her within 4 weeks of the hearing. The petition is disposed of.
My lord, I was praying if it could be kept pending till DMT, till I meet the
No,
DMT.
no, let him,
So that it will go
let him
further.
decide the issue,
Your
then
Lordship
if
knows.
he is agreed by that
Yeah.
order, she can
Right.
again.
If any cause of action still survives, it will be open to the petitioner to seek appropriate actions.
Obliged.
Item number 3.
May I please, Your Lordship? In item number 3, first sub-item, Mr. Pranay Mahanti has engaged Senior Counsel Mr. Buddhadev Rautray. In the first matter, the appellants are challenging the impugned judgment dated 11/7/2022 under Annexure 1. In similar matters, Your Lordship has already issued notice and passed an interim order and fixed the matter to 10th of May.
That's the first subjective.
Yes, Your Lordship.
I am in the observer of the matter.
At least second at all.
I am in the observer of it. 1090.
Same.
The same I.
Yes. All right. See. Notice returnable 10. Status will be maintained till then. List along with WA number 1082/2020.
In the first matter, I'll accept notice for OPC, Your Lordship.
I will serve a
Both
copy.
matters,
Your Lordship.
I will serve a copy.
he accepts for OPC.
Lord seeking pardon. Lordship, I'm seeking just pardon.
Yes, please.
My lord, I am from Delhi. It's a very emergent matter, Lordship. That's why I am mentioning and seeking pardon that I am intervening in the middle of the court. Lordship, on the 19th, I had mentioned a matter, real appeal matter before Honorable Justice Sahu. The minor daughter was very seriously ill. I sent all the documents to the court master, sir. And on the next day, the real appeal was heard. Honorable Justice told me that you filed IA. I will not take it for consideration, all these documents. I filed IA on the same day, and the matter was fixed for 26th. Yesterday evening, that minor died, Lordship. And she is in the hospital waiting for the father. In the morning, just now I have mentioned the matter, but Honorable Justice is saying no, I will not hear it today. I will hear it tomorrow. Now the minor girl is dead. She is in hospital waiting for the father. There is sufficient measures in the CRPC to release the bail, to release the accused on bail. It can be on the.
No. You wanted an interim bail now.
Yes, my lord. Interim just to participate in the privacy. Lordship, she is a minor girl. I have submitted all the documents. And what is the guilt of that minor girl? And he is in jail from last 3 years. He is a local person of the state of Odisha, Malkangiri. So there is no chance of any absconding or like that. And even
No,
last.
but that's okay. But this has to be actually mentioned before Justice Sahu.
Yes, my lord. I had just mentioned.
Tomorrow.
Yes, my lord. He's saying for.
But the child is died.
She has died, your lordship. The deputy cannot wait for the 48 hours or 72 hours.
We'll fix it at 2 o'clock, sir.
I'm obliged. Deeply obliged.
Item number 4.
Item number 4, Your Lordship. Your Lordship, here the appellant has challenged order dated 24/3/2023 by WPC number 14258 of 2022. Your Lordship, in this matter, Mrs. Pamirat is going to argue this matter, and Your Lordship, she is arguing in length.
Pass it over.
Your Lordship, can I pray for take it up at 2 p.m. after the PL matter, Your Lordship?
No, we can't say that. Let me just pass it over. You get ready with the matter. We'll see. All right.
Item number 5.
May I please, my lord? My lord, here the petitioners are the photographers who are doing their photography.
Konarak. This is Konarak.
Yes, my lord. Yes, my lord. What I want to submit, my lord. The fate of this issue raised in this petition had already tested before this honorable court. My lord, please to direct that those who have identity cards issued by the tourism department, they only will be allowed. My lord, now, my lord, I'm just refreshing the memory of my lordships, my lord. Running page number 60, my lord. Running page number 60, order passed in writ appeal.
Right.
Since it is a question, I'm reading, my lord. Since it is a question of livelihood and considering that they have been functioning as photographers even during the pendency of the writ petition, on a balance of convenience, it is directed that subject up to the ASI and district administration regulating the entry of the appellants into the monument on the basis of the identity card issued to them by the tourism department, only such of those appellants possessing such cards will be permitted to operate in the monument till further orders from the court.
When is this coming up?
It is coming in May, my lord, but my humble submission is
Which date in May?
my lord, it is 17th May, my lord.
Or did we issue notice of this? What?
Yeah, yes, my lord. My humble submission, my lord. My lord, kindly have a glance to page 63, my lord.
Yes.
Here the confusion started. Page 63, running page number 11.
Let them reply. Let them reply.
Yes, yes.
I'm appearing for the Union of India, my lord. A copy may be served on us.
All right.
My lord, one humble submission, my lord.
Yeah.
Here, my lord, please to direct to allow the photographers, those who possesses identity cards. The tourism department had clarified to the ASI that no such identity card had been issued by the tourism department. It is only the ex-tourist officer who had issued 110 number of identity cards. Basing upon that, they are not allowing a single photographer. They are not allowing as on date, they are not allowing a single photographer. My humble submission is, during last funny cyclonic storm in 2019, the collector had made an survey and give a report to the tourism department, basing upon which the chief minister relief fund of
let him reply, Mr. Mohanty. This is the first hearing of this petition.
Yes, my lord. First hearing of the case, but no one is allowed, my lord.
Accepts notice on behalf of respondent number 1 and 2 and 3.
Three, my lord. It is 3.
1, 2, and 3. Mr.
State is the yes, my lord.
State who will accept? Who will accept? Mr.
Yes,
D.K.
sir.
Mohanty accepts notice
No.
on behalf of 4, 5, and 6.
Copy has not been served.
Copy served just now.
Yes.
Copies be served today itself.
No, only 1, 2, and 3, no copies.
List along with, list along with petition civil 3633/1 of 2021 on. Is it 36? No. Sorry. List along with WA number 81 of 2022 on 17th May.
17th May, my lord.
All right.
Will file counter.
Replies be filed at least 3 days prior to the next year.
My lord, one last line, my lord. No, they are allowing not a single photographer, my lord.
Today we can't pass an interim order. We'll have to hear them. All right.
Item number
Sir,
6.
I am taking notice for opposite part note 5,
4, 5, and
4
6.
to 6.
4 to 6.
A copy served, my lord.
Right.
Item number 6.
Password.
Item number 7.
Item 7, may I place it?
Well, my limited grievance will receive the annexure 3, which is page number 11, that is pending for opposition 4, my lordship. Tahsildar Tangi, my lordship. That is in annexure 1, my lordship, that the land is recorded in the name of the present petitioner. And annexure 2, that the land has been encroached by the private opposite party number 5, 6 to 9.
All right. You see, the petitioner's representation packet
Tahsildar
will
Tangi.
be examined by the Tahsildar Tangi. And after notice to the petitioner and opposite parties 6 to 9 and giving them a hearing, the reasoned order shall be passed not later than 1st August. Be communicated to the parties not later than 8. The court clarifies it is not expressed in it.
Obliged.
Item number 8.
Item number 8, my lord, the petitioner's pair is for the enforcement of the village land, that is jungle land, and the petitioners along with other villagers are dependent upon the land for the grazing of their cattle from their time of forefathers, and they are very poor people. But the opposite party number 5 and have been enclosed and constructed boundary.
All right. The petitioner's representation shall be examined by the Tahsildar Jatni. And after notice, the petitioners and opposite party number 4 and giving them a hearing. A reasoned order shall be passed not later than 1st August. And be communicated to the parties within a week thereafter. All right.
Item number 9. Item 9.
Pass.
Item number 10.
Item number 10, your lordship. here I am praying for relocation of school on the ground that within the school premises there is a transformer as well as a water tanker also.
All right.
And the school
Petitioner's representation.
Yeah,
bracket
Lordship.
Annexure 4.
Copy.
Shall be
Copy the-
examined by the
Put 10.
video.
Yes.
Video Puri Sadar. And after notice to the petitioner giving my hearing. The reasoned order should be passed not later than 1st August and be communicated to him within 8th August. All right.
deeply obliged.
Item 11.
Sorry to mention, your lordship, some pages inadvertently missed. For that reason, I want 1 week time.
All right. Defects, you say, list on 4 July. Defects we cure.
In the meantime, defects will be removed.
Item number 12.
My lord, the State Food Commission is running without any chairperson and 5 members. Not a single member, not a chairperson is there.
I will take instructions. Same issue. But
It
it
is
is
stated
raising
that
very important issues.
Neither chairperson nor the posts of 5 members of the Orissa State Food Commission has been filled up. And therefore, there is a violation of Section 16 of the National Food Security Act 2013. Say notice, Mr. Mohanty accepts notice on behalf of the opposite parties and states the reply will be filed within 4 weeks, rejoined up for the next day.
Item number
1 minute, sorry. 12th July. No,
Obliged.
sorry, 13 July. 13 July.
Obliged.
Item number 13.
Lordship, as per last Lordship direction, I filed the amendment petition, my lord. The Tata Power is now the TPCU rails. Well, here is the case, my lord, challenging the order passed by the single judge in 2016 about a meter stamping, my lord.
All right, just 157 of 2022, the application is allowed. The substitution is allowed. The amended memo. The consolidated cost had to be filed within 2 weeks. What about the main matter? The notice returnable. 21st August.
Yes.
Item number 14.
Nana Pest dismissed.
Item number 15.
My lord, what I find that if appeal has been filed against the division bench order, your lordship may give me time, I will examine.
No. You
I am
withdraw it and
surprised
take
that
other-
how this appeal could be filed.
It's all right. Counsel for the appellant seeks leave to withdraw the present appeal. To seek
This
other-
appeal is filed against the order of passed in WPC 5649 of 2012, page 21. Your lordship may verify also. Page 21 of the appeal memo. And it is disposed of by
by DB, correct.
division
To seek
bench.
other appropriate remedies as may be available in accordance with law, disposed of is withdrawn with liberties. All right.
Item number 16.
Nana Pest dismissed.
Item 17.
17 in Lordship are passed identical orders.
17, I may permitted to withdraw with my liberty to file a review
Petition. This order has been passed.
Yeah, same one. All right.
Item number 18.
May please, Lordship, here, my lord, the petitioner is challenging the Honorable Single's order by the annex of 12 matters. Here, my lord, this whole question is, already counter has been filed in a writ petition, a counter has been filed by the ESI Corporation. Without ignoring that counter, my lord, this case has been disposed of. I am challenging here, my lord, annexer 2, your lordship.
Appealable one, sir.
My lords,
You are permitted to file an appeal.
the under section, my lord, admittedly under section 75, there is a provision, but so far there is a violation of natural justice. Honorable,
That you can raise in the appeals. As much as the impugned order merely relegates the appellant to the statutory remedy of an appeal under section 75 of the ESI Act, the court considers it and does not consider it necessary to interfere with the impugned order. The appeal is accordingly dismissed.
time may be allowed some time, my lords.
That will do, sir. You explain in that delay, you'll have to explain. Yes.
Item 19.
My lord, in this matter, no instruction, your lordship pass any order.
All right. No instructions dismissed.
Item number 20.
item 20 sarta pada. 8th May.
8 May. All right.
Item 21.
21 only, Lordship, may kindly see page 27. 27. In this case, these 2 persons were terminated. Myself and one Bhagavat Senapati.
What my limited prayer is, the said Bhagwan Senapati had approached this honorable court, and this honorable court gave him liberty to approach the principal. And he approached and he has been allowed to continue. I seek that I'll approach the option number 3. He will decide my.
My lord, I am appearing for the private respondents. Kindly see the prayer, my lord. My lord has prayed to quash the advertisement dated. My lord, kindly see prayer.
My prayer is not innocuous.
For a moment, my lord. If the representation will be disposed of lordship direct, kindly that will be a problem. My lord, kindly see for a moment page 13, my lord. There, he has prayed to quash the advertisement dated 19/12/2019 that has been challenged by myself in another writ petition that has been stayed, my lord. It will be.
He's not confined. He's confining his prayer to not. He doesn't want that prayer.
Since the other person had approached this honorable court,
he's saying he will approach the
OP number 3.
principal.
My lord.
The concept of the appellant states that the appellant will be satisfied if an order similar to the order dated 2nd September 2021 in writ petition civil 25805/2021 bracket Bhagwat Senapati is the state of Orissa bracket is passed in this case as well. Paragraph. Considering the limited nature of the above prayer and having perused the above order, the court directs that the representation of the present appellant will be considered by the principal Hope College,
my lord,
and an appropriate decision will be taken. Where is your representation?
I'll file a representation.
No. That if the appellant makes a representation to the principal Gop College, not later than 15th May 2023, then such representation will be considered in accordance with law, and an appropriate decision would be taken thereon within a period of 2 months. The court clarifies it has not expressed any view on the matter. The decision be communicated to the appellant within a week of its being taken. Agreed, it will be open to the appellant to seek appropriate remedies in accordance.
Without being influenced by the impugned order.
No, my lord. That's since I am the.
What?
Since in this, I want to the matter should be adjourned, I will file a detailed counter, my lord. I have challenged that very next advertisement which has been stayed by an honorable single bench, my lord.
Then only this much order is there, my lord. No problem.
All right.
My lord.
Okay. Yes.
Item number 22.
Created a petition, my lord, filed a petition for condonation of delay, my lord.
Yes.
The order of the single judge was passed on 2nd January 2020, my lord. And,
all right. Now come to the merits.
Merits, my lord, another defect is there, my lord. My lord, the appellant's case, my lord, while he was junior clerk and a cashier, my lord, and subsequently became senior cashier, some allegation was made that he has paid 54,000 and some odds to the 2 different persons who are CC accounts in that bank, my lord. The disciplinary proceeding was initiated, my lord. The disciplinary authority, the inquiry officer himself called the inquiry and imposed the punishment, my lord. My case is that, but he was appointed as inquiry, he cannot be a disciplinary authority because in read application, also will see that he was only appointed as inquiry officer. And that appointment, he was functus officio, he was at Baroda, my lord, not in Orissa, my lord. And that apart, as per the guidelines of the bank, my lord, he cannot be disciplinary authority. That is my case. But the honorable court, citing the decision of the taken the Desai Commission, my lord, hold that can be appointed. But here in the case, my lord, he has not been appointed as disciplinary authority, my lord. And that apart, the money which was said to us, that has been returned by that has been paid.
That makes it worse, sir. Mere return of money does not mean that you've not committed the misconduct. It actually makes it worse. Which means you're admitting to the misconduct.
Your lordship may keep it to next week, my lord. I will satisfy because for order of matter or the matter of the order, my lord, I am not fully prepared today, my lord.
Counsel for the appellant states that he is not prepared to argue the merits of the matter yet. Consequently, at his request, list on July 19.
Item number 23.
No instructions dismissed. Memo taken on record.
Item number 24.
I use this matter urgent to 24th August 2023.
Sorry?
Use Alok Mishra case, madam. 21st August.
21st August.
I am giving that copy.
Item 25.
My lord, item 25, my lord, I'll, for 2 weeks time may be allowed to remove the defect, my lord.
Not 2021 matter, sir.
21 matter.
This is a 2021 matter.
Yes, my lord.
So you can't give me more time for this.
Certified copy. 1 week maybe.
No. Tell us what the matter is.
My lord, in this case, my lord, that the honorable single judge passed orders ex parte, that is page 60. Your lordship kindly have a glance that this matter is taken up, that considering hard learned counsel for the petitioner, there is a serious allegation in the matter, non-release of subsistence allowance. Considering this to be a case of non-release of subsistence allowance being violative of law, this court, though not expressing any opinion on the merits.
You should have easily considered this. This is not against you. They only ask you to consider.
My lord, what happened in this case? Why I am challenging that writ appeal? Your lordship kindly have a glance that the grounds taken by me in the writ appeal. Your lordship kindly have a glance. First, the appellants having not been given any notice from this honorable court before passing such orders.
There is no direction to you that you should allow that subsistence allowance. It's only to consider. And if it is admissible, release it. If it is not admissible, don't release it. It's an innocuous order. The impugned order requiring the appellant to dispose of, to look into open quotation, look into the grievance of the unquote respondent regarding non-payment of subsistence allowance is an innocuous one. Full stop. It merely states that the appellant will release subsistence allowance, open quotation, as due and admissible, unquote. Stop. Given the innocuous nature of the direction, the court finds no grounds to interfere. The appeal is dismissed.
My lord, your lordship kindly have a glance that all the just I am coming before your lordship that the criminal case is pending.
3 years are over now, right?
My lord.
No. In these 3 years, you have not paid any subsistence allowance. You have successfully avoided implementing the order. Now, by now, the inquiry should be over. 3 years are over. Inquiry should be over, or inquiry is also not over.
My lord, what happened is in this case, my lord, this is a case that
Sir, whether inquiry is over or not. Sir, whether inquiry is over or not.
He is prosecuted under a criminal proceeding, my lord. I have no instruction regarding what.
When you argue a matter like this, you should first come with the full facts. Only then you can argue. Otherwise, you will just be going around in circles. Yes. You're now familiarizing yourself with the matter. All right. Next part.
Item number 26.
Yes. Who's in 26? Memo taken on record. Dismiss this withdraw. Right.
My lord, kindly withdraw the matter.
Yes. Dismiss this withdraw.
Item 27.
The appellant is unwell. So list on. The counsel of the appellant is unwell. Sorry. List on 25th July.
Item 28.
Nana based.
Item number 29.
Item 29, Sartapada 8th May.
8th May.
Item number 30.
Item 30 may
There is a delay of 1,056 days.
Tomorrow my file is misplaced.
1,056
File is misplaced. Tomorrow, if there is
judgment dated 17/5/2018.
He says the file is misplaced. Tomorrow.
Tomorrow. I am saying for tomorrow.
All right. Tomorrow.
If it is delayed.
Item 31.
None appeals dismissed.
Item number 32.
32 Sartapada 8th May.
8th May.
Item number 33. Item 33.
None appears dismissed.
Item number 34.
Item 34, a delay of 82 days, my lord.
Come to the merits, sir. Come to the merits.
Grounds we have taken that the earlier advocate has was appearing for the appellants had expired during pendency of the writ petition, which fact was not known to the appellants, for which the writ petition is disposed of as uncontested. That fact was not considered by the honorable single judge. And since the advocate of the appellant has already expired, which was not within the knowledge of the appellant, the case was disposed of as uncontested for which the relevant.
Uncontested. Just come to the impugned order, page 11. Where is it uncontested?
For opposite party. The question.
Where is it uncontested?
Mr. Mahapatra has expired. That Mr. Akhil Mahapatra, who is appearing on behalf of the appellant.
He is expired.
Expired at that time.
Then you should file a review petition, sir. Counsel for the appellant states that the counsel appearing for the appellant, that is opposite party in the writ petition, Mr. Akhil Mahapatra, had already expired by the time the writ petition civil 5512 of 2003 was heard. And therefore, no arguments could be advanced on behalf of the appellant before the learned single judge. Full stop. The impugned order also does not reflect the arguments of counsel for the appellant. Full stop. That was the matter permitting the appellant to file a review petition. In accordance with law, the appeal is dismissed.
Liberty maybe. Liberty maybe.
Yeah, liberty. Delay control.
File review.
Yes.
Name of Mr. Udgata for OP number 2 will reflect. Name of Mr. Udgata appearing for opposite party number 2.
Opposite party number 2 is who?
Yes. My Lord Chancellor.
Chancellor, all right.
Item number 35.
My Lord, item number 35, my Lord. My Lord, we have sought for up-to-date instruction regarding the present status of the land, my Lord, regarding possession, my Lord. It may kindly be taken up some other date, my Lord.
No, tell us what the matter is.
My Lord, due to some discrepancy in the publication of the map, my Lord, the opposite parties are disturbing the possession of the petitioners, my Lord. But by this order of this honorable court, my Lord, it was directed to take instruction, my Lord, but without submitting any document, they have stated that the map has been corrected.
You have been provided, other remedies are always available to you, sir, because it's already been published.
My Lord. My Lord, one date may kindly give it so that I can take instructions.
No. You see, the impugned order notes that once the final ROR as well as map has been published, and notification under section 41 of the OCH PFL Act has been issued. The earlier order dated 15 September 1999, passed by the consolidation officer, can no longer be implemented. The court finds no error having been committed by the learned single judge in coming to the above conclusion. It is further noticed that the right of the appellants to seek other remedies available to them in accordance with law has been reserved. Paragraph, there are no grounds made out for interference. The writ appeal is dismissed.
Item number 36.
8th May.
All right.
Item number 37.
Your Lordship, I am appearing for the appellant in item number 37. Your Lordship,
Yes.
there is scope of revision as well as provision of revision under section 12(2) of the Odisha Prevention of Land Encroachment Act. Revision lies to the collector. I'm accordingly liberty may be given to approach the collector under the revision jurisdiction. Here the appellate order was passed by the sub-collector under section 12(1), and under section 12(2), there is provision of filing a revision
This
to
is
the collector.
no. But this you did not urge that. So the impugned orders decides the matter on merits now.
Your Lordship, but there is scope of revision, my lord.
You should have told that to the single judge, sir. You did not tell that to the single judge. It has now been decided on merits.
Your Lordship, I was not the counsel in that case.
That's okay. Can't be helped, sir.
Your Lordship, I may be allowed to withdraw the application with a liberty to file a revision petition. Time is there.
No. So once you allow the writ petition to be decided on merits, to now say I want to file a revision does not arise. Sir.
A revision scope is there, my lord.
But you should have exercised that before filing a writ petition.
This point was
You filed a writ petition. You did not take this point before the single judge. The writ petition has been rejected on merits. Now you cannot turn around and say, I want to avail the alternate remedy. Yes.
Your Lordship, in that case, I need some time for preparation. Let it come in the next week on any day.
Counsel of the appellant wants to avail of the alternate remedy of revision. Full stop. However, this plea was not taken before the single judge, and the writ petition has been dismissed on merits. Full stop. It is therefore not possible to accede to this prayer of the appellant. Paragraph. Counsel of the appellant then states that to argue on merits, he needs more time. Full stop. List on. July 27.
Item 38.
Yes, my lord, here. The collector's order is challenged before the Honorable High Court. Honorable High Court disposed of the case basing upon a judgment passed in writ appeal number 506 of 13, annexure 4. But the fact and circumstances in the writ appeal at the present case, as Honorable Judge consider, is quite different. The case is that mirror point is that it is a settled position law that part choco cannot be sold to a stranger who have no land adjacent to choco land, and if made such transfer shall be treated as void. And when the petitioner came to know such and such the position of law, and it goes against the statute, section 34 and 35 of OCH Act. Because of the settled law, collector rightly passed the order. But Honorable Single Judge disposed of the case in accordance with writ passed in the White Annexure 4, writ appeal number 503. The case is that in that land, many developments made, like warehouse, like way bridge, installation of transformer, and other developments. So Honorable High Court take a lenient view, considering such big development, big investment made. So they allowed that case taking a lenient word. But the case is not like that. Nothing has been occurred. No development has been made. Only paper development behind back of the appellant. And development regarding, I have also annexed a photo of the land page, annexed 40, page 47, the color photo regarding the claim development. On the ground, the Honorable High Court disposed of that has many development like installation of transformer, one-way bridge, another construction of building. But here nothing has taken place, only paper development. Not a single money has invested. The photo is before your lordship, page 47. So disposal, my humble price, disposal by Honorable High Court basing upon the writ appeal judgment is not, that judgment not squarely applicable in my case.
Counsel of the appellant contends that the
it goes against the statute, Mr.
judgment in Sutar Chemicals Private Limited versus Collector Baleshwar 2015-1 OLR 394. Is distinguishable on facts and is not applicable to the case B. appellate. You see notice return of 27th July. Defects be cured in the meanwhile.
Item number 39.
Obliged period
39, 40, 41, 42, 43, 44.
my lord, my case disposed of or kept for some.
No, issue notice.
45,
Okay.
46, 47, 48, 8th May.
All right.
Sartapad.
All right.
39 to 48. Item number 49.
The RSCP matter, madam. It's a RSCP matter. The similar matter has gone to Honorable Apex Court. Yesterday, the Honorable Apex Court has stayed it. So you must issue notice in this. Relying this judgment, this Honorable single judge are directed to grant him RSCP. That has been stayed before the yesterday.
All right. It is stated that the SLP filed against the judgment in State of Orissa versus Bihari Lal Barik.
No, but not we are like that's Saraswati. That Saraswati Bhoi, my lord.
Right. Okay.
You also can find it from page 58 of my writ appeal. That Saraswati Bhoi, that case was.
No, this is the OAT's order.
Yes, madam.
No, what you're challenging here is the 110-2020.
Yes, madam. That illustrates the impugn order is at
page 19.
Madam. That there, the Honorable Court has directed illustrates that in view of the writ stand dispute to direct the appointment to consider the claim taking into consider the decision in similarly situated cases, right? Annexes 6 to 8.
That includes
Saraswati Devi.
All right.
Saraswati Bhoi, sorry.
No, but which is the matter in which SLP has been filed?
Saraswati Bhoi case.
Right.
Saraswati Bhoi case that was challenged before my lords. So it was, we lost here. Thereafter we went to our.
Where is our order in Saraswati Bhoi? Where is that?
Saraswati Bhoi order is not annexed here. That they have annexed 6 to 8 in a batch of cases that was Saraswati Bhoi and others. That's a batch of cases. So in all those cases, the state lost here, man.
But Bihari Lal Barik has been dismissed. SLP is dismissed.
Yes, Bihari Lal Barik stands on a different footing.
I see.
That relates to that VLW promotion matters. These incumbents are private school teachers.
All right. It is pointed out that against the order of the Orissa Administrative Tribunal, in the case of Saraswati Bhoi and others, against the order of this court, dismissing the state's writ petitions, SLPs have been filed at the Supreme Court of India, in which yesterday, that is 24th April 2023, notice has been issued and stay has also been granted in favor of the state. Paragraph. Notice returnable. There's no, we don't know the date. We'll have to have a separate batch now.
Yes, but it will be a separate batch. You'll also have fix.
Notice returnable. August. There shall be stay of the impugned order till then.
Item number 50.
8th May.
Yeah.
51.
But I'm not feeling well.
Counsel to the appellant is stated to be unwell. List on. August.
Item number 52.
52, 54, 50, these matters are of the special list that DLR regulation.
When is that? For this, today's. Yeah.
Today's.
All right.
It can be taken up along with that.
Along with that, correct.
52 and 54.
52 and 54.
54, 56, 57, 58,
60.
59, 60, 64, 65, 66, 68, 72. These matters can be taken.
Regulation.
Special list.
53.
Item number 53.
My lord, 53 permitted to withdraw as there is a civil suit already initiated before the complete court bill.
At the request of counsel for the appellant, dismiss this withdrawal.
Item 55.
55 is 8th May.
8.
Item 61.
No instructions dismissed.
Item number 62.
62 rehabilitation 30th August.
Item number 63.
63 short of 8th May.
Item number 67.
67. Full and mass.
67 short of
Item number 69.
69 will see regarding the time-bound advancement scale, the lordship can find from Annexure 3 the impugned judgment. There may be Honorable Single Judge has not taken into account the Finance Department notification dated 19/29/2002 at Annexure 4, page 56. That only classification is that on completion of 15 years to a upper higher scale, he is not entitled to TBA. That is the clarification. That has not been taken. That has been interpreted that he has held the post, even if he has gone to the higher scale, he is not entitled to that. Your Lordship can find it page 56, Annexure. Clause 2(1). The period of completion of 15 years of service in a post or grade is counted with reference to post held if there is no upgradation in the scale of pay to that post or the incumbent has not moved to a higher scale of pay because of hiring higher qualification. However, if the incumbent after acquiring higher qualification has moved to a higher scale of pay, even though holding the same designation of 15 years for the purpose time-bound scale would be counted from the date on which the incumbent has moved to such higher scale of pay.
That IA, you say there is no delay and so it is disposed of. 196, 194 is disposed of, 186 dispense with, that's disposed of. In the main writ appeal, you say notice returnable. August.
Item 70.
Well, there shall be stay of input order.
Just notice on stay. There's no, is there an application for stay? I didn't find it.
Yes.
65. Yeah, I put notice in IA 195 2022 also. Right.
Item number 70.
None of this dismissed.
Item 71.
71. It may be taken up any other day because one of my associate was appearing, so I have been.
Notice is no requisites not filed.
In that case, I cannot submit because in that case, you also take up or my learned friend's name may be recorded.
Yes. All right. But what is this matter about?
There's regulation.
No. Data entry operators in various types. This is covered by Patita Bhavan.
71.
Patita Bhavan.
Perhaps not
covered by Patita Bhavan.
No. Will also be holding 71.
855. Writ appeal 855.
No, that is not. In fact, it's not that. Not data entry operators. My lord, that is a class for employees.
No. Just see this.
Order is that has been covered with that order, my lord.
Judgment dated 30th November 17632. Oh.
That has been covered with that data entry operators case. Lordship, we can fix it to 11.7 that on similar matters have been fixed.
Achha. All right.
My learned friend's name. Maybe.
All right. You say Mr. Kuntia is unable to appear in this matter for the state. Mr. D.K. Manti instead will appear.
Yes.
Fresh notice returnable 11th July.
11th July.
All right. Interim order to cut.
Item 73.
73, my lords, has been pleased to place this matter on 3rd of July in a connected matter.
What is the connected matter?
The connected matter is as regards this matter is a joint decision of the single judge, which had come up before your lordship on 21/4.
What's the number, sir?
And that's 367 of 2023.
List along with 367 on 2023 on 3rd July.
3rd July.
All right.
Oh, bless.
74.
74, my lord, promotion during pendency of criminal case 11th May, your lordship.
All right.
Item 75.
Which is authorized not well, my lord. Maybe taken it some other day.
Counsel with the appellant stated to be unwell. This on 29th August.
Item number 76.
My lordship, item number 76 is similar with item number 100, your lordship. Both are same judgment we are challenging. So it may be kind of taken up with 100.
All right.
Item 77.
77, 78, 79, 80. 8th May.
Item 81.
81 was 30th August.
Yes.
Item number 82.
82 workers 14th September.
Item 83.
14th September.
Item 84.
Also 14th September.
Item number 85.
The promotion during pendency of vigilance case 11th May.
Item number 86.
A job contract 14th September.
Item number 87.
14th September.
All right.
88. Item 18 on behalf of Miss Patnaik. See, now she is suffering from cold fever.
Counsel with the appellant stated to be unwell. 29th August.
All right. 89 is
take it about two.
Item number 90.
I may plead your lordship. Here is a case I filed an interim application. Here, case in original manner, the equal pay for equal work. The petition is continuing on contractual basis for last more than 10 years.
Yes.
He is initially challenged before the single judge that he is entitled for the minimum scale pay at par with the regular employee plus grade pay and other benefits, excluding increment as decided by the Supreme Court in time to time. But here during the pendency, they have revised the pay. As due and admissible minimum may be granted during the revision.
You have to file a date chart. What happened?
I filed a date chart.
See, counsel, the appellant needs some more time to file a date chart.
All right.
List on 4th September.
91.
May I please, your lordship? May I please, my lord? My lord, here that is with regard to the apportionment of the policy benefits. My lord, therein your lordship will kindly refer to order dated 22/11/2022. My lord, on behalf of the contesting respondent, it was stated that they have no objection if the amount is disbursed in favor of the present appellant. Your lordship was pleased to record that. Now, he is unable to file an affidavit despite lapse of time. Will your lordship be kind enough to take note of this submission and dispose of, my lord, because he says that he is bedridden, the respondent.
Who's for the LIC?
I am appearing.
No, I'm not for the LIC.
I am appearing for LIC.
They will not have a grievance because
No, so far
it's-
the legal position is concerned, my friend is correct because class 1 here are the wife, sorry, widow, mother and the minor child.
Yes.
Nominee was the father. So the allegation is the nominee wants to take the money.
All right. All right. On 22nd November 2022, the following order was passed. Correct. Today, counsel for the LIC informs the court that they would have no objection to making over the entire amount to the present appellants. The joint affidavit of respondents 3 and 4 is already on record.
no matter, that is the difficulty because he is bedridden. He is not able to file that. But the council on instruction made a submission which your lordship was pleased to take note of.
All right. Counsel for respondent 3 and 4 state that respondent 3 is bedridden.
Bedridden. Respondent number 4 has died. So
Respondent 4 has died and respondent 3 is bedridden. But the instructions are that they have no objection. Paragraph. In that view of the matter, a direction is issued to the LIC to make over the entire amount to the appellants within a period of 6 weeks from today.
As your lordship pleases.
Right. The appeal is disposed of in the above terms.
Grateful man.
60 days, my lord?
6 weeks.
Week. Lordship, 6 weeks. 6 weeks. All right.
Item number 92.
92 mal regulation. In this case, I am for the respondent. I filed Vaklatnama yesterday along with affidavit, but that is not on
Regularization is otherwise coming up when?
2 days.
Today.
And this is the first day disposal.
First day disposal, can it go back?
Page 15.
But this has to be with other matters, right?
Yes, ma'am.
How many such matters are there?
Around 200.
So it will have to be staggered by the single judge then. All right. You see he enters appearance on behalf of the, this is 90?
92.
Niharanjan Sahu. Okay. On behalf of the respondent. It is seen that the impugned order was passed on the very first day without opportunity to the present appellants to file any reply. On that short ground, it's hereby set aside. The writ petition will be listed before the learned single judge in the roster bench on 28th August. I think we'll say 30th August. On 30th August, the Parav's reply to the writ petition will be filed by 14th August and rejoined thereto if any on or before 30th August. No further time will be granted to other parties that purpose. Sorry? It's all right. Affidavit on behalf of the respondent. The delay is condoned. This is basically for the delay. The writ appeal is disposed of.
Item number 93.
93 my 8th May.
8th May.
Item number 94.
94 mal regulation matter that your lordship can take up with that special list.
Correct. With specialist.
Item 95.
95 that also old pension that is also in the special list in item.
All right.
95 and 96.
All right.
97.
97 was special list.
All right.
98.
98, my lord. I am for the opposite party, and basing on who is the honorable single judge has passed this order. In that case, has already been implemented by the government. But by suppressing that, they have obtained the stay order. You will also kindly have a glance these documents, man. Basing on the order passed by word number 151,
by 2010, filed by Markonda Naik, the Honorable Single Judge has passed this order, my lord, extending to 2 years benefit.
My lord,
In that case has already been implemented.
he's confusing, my lord, that in Markonda Naik case, he does not stand with that same person. Like our stand in this case, and if he had first submission, if we have misguided my lords as if that has been implemented. That our case is that he is a class group C employee, not being a group D employee, he cannot be covered that 60 at the age of 60 years, my lord.
And Honorable Single Judge has passed this order. You will also kindly have a glance the order.
Your lordship,
Kindly have a glance the order at 2921.
let me finish.
Yes, 2921.
Your lordship, what is the order and what is our ground?
Yes. The order, my lord, you will also kindly have a glance basing on the OA number 151 of 2010 and which is squarely applicable to the case of the petitioner.
That is the point, sir. He says it's not applicable.
That is the point.
That has already been implemented. You will also kindly see.
That may be, but if your case is not covered, he says your case is not at the same footing as Markandeya Chandra Naik.
Honorable Single Judge basing on that order has been
That
passed.
is why he's in appeal, sir. He says that is a mistake.
Is that our case, my lord, that those who have come to the group C category, work charge employees, they are not covered under 60 years of age of superannuation.
So this again, first day disposal.
This is not a fight, this is a wave transfer matter, my lord, that's first day disposal.
After counter has been filed, thereafter order has been
My
passed.
election is my group ground B, my lord, of my writ appeal. That is specific stand, my lord. He has been treated as group C employee. So in respect of work charge employees of group D, the retirement age is 60 years. In respect of group C, that is 58 years.
And he is a group C.
He is a group C.
No, that was challenged before the OA.
Markandeya Chandra Naik is group D.
Group D.
No, Sam, Markonda was retired at the age of 58 instead of 60.
Because he's group C.
No,
he's group D, you're group C.
No, both were in the same footing, same establishment.
Not footing, no.
Executive engineer, Salandi Canal Division, both were. And you will also kindly see Markonda Naik, he is also group D employee, but treating him as a group C, retired at the age of 58, that was challenged. And the Honorable Learned Tribunal has allowed.
Markandeya Chandra Naik group C or group D?
Group D, my lord.
When he retired? When he retired?
At the age of 58.
Kebbe retired kala kona?
No. Let's be clear, sir. Markandeya Chandra Naik is group C or group D?
Group D, man.
Group D. And you're group C.
And I am also group D. But treating both were in the group C.
Yes, I am
challenging the notice.
I am clarifying. Well, as per the 6th Pay Commission, but the group C, group D, and group B posts are classified under the scale of pay rules. Those who are coming under the scale of pay rupees 4,400 to 7,440 under the 6th Pay Commission, they are treated as group C employees. So he was fitted in the scale of pay of rupees 4,400 to 7,440. Also, my ground B. Page A5,
yes.
The respondent was brought about to the work charge establishment in the post of work worker under the scale of pay rupees 4,440 to 7,440 with grade pay of rupees 1,650 by office order number 1424/9/2009 of the Chief Construction Anandpur Barrage, which comes under Group C category post as per ORSP rules 2008. Once he comes under Group C category, he is not entitled to.
But where do we get that Markandeya Chandra Naik is Group D?
Yes, ma'am.
Where do we get that?
He is saying that Group D.
No, who's saying it?
That my learning friend is saying.
No. He says Markandeya Chandra Naik also is Group C.
Like, if he has retired prior to 1/1/2006, what has happened? Well, as per ORSP rules 2008, on the basis of scale of pay, that post has been defined.
You answer this question, sir. Markandeya Chandra Naik, is he Group D or Group C?
He is a Group D employee. If he has, why I am submitting on, if he has retired prior to 1/1/2006, he has not come under that ORSP rules 2008. As per the classification of post has been made as per the ORSP rules 2008. On the basis of scale of pay, they have been treated as Group C and Group D. If he'll clarify, if he has Markandeya Chandra Naik has retired prior to 1/1/2006, he has been treated as Group D, there is no problem, my lord. If he has retired after 1/1/2006, then he is covered by the Markandacharan Naik case.
When did Markandacharan Naik retire? Why don't you see this order, this implementation order? It will get an idea.
Yeah, he has given the
because Markandacharan Naik workers Sarkar work charged, it says.
2 years benefit has been extended to him.
Just see that. So it says work Sarkar work charged.
Yes, ma'am.
So he's identical with the present response.
Yes, my work subject identical. If that is the only date of retirement. That it appears, my lord, you will also find it from that document. That 1/4/2010 to 4/21/3/2012. If that is 1/4/2010, my lord, it must be after 1/1/2006.
Yeah, it's obvious.
Yes, that I am saying. If it is 1/1/2006, then he is covered under that.
Yes, covered.
Yes, ma'am.
All right. It appears that the impugned order has been passed by the single judge in favor of the present respondent after noting that his case is covered. Is identical to the case of Markandacharan Naik, in whose favor the Odisha Administrative Tribunal, Cuttack Bench Cuttack bracket OAT, had passed an order dated 28 February 2017 in OA number 151 bracket C of 2010, permitting Markandacharan Naik to continue till 60 years of age. Paragraph. In ground B for Bombay, of the writ appeal, it is sought to be contended that as far as the present respondent is concerned, he was brought over to the work charge establishment in the post of work Sarkar under the scale of pay of 440-7440 with grade pay of 1650, which comes under group single quotes C category post as per the ORSP rules 2008. So therefore, he cannot be treated as a group D post and be allowed to retire at the age of 60. Paragraph. Counsel, the respondent has produced before the court copy of an order dated 27th August 2019 issued by the Department of Water Resources implementing the decision of the OAT in favor of Markandacharan Naik in OA number 151 bracket C of 2010. Paragraph. The implementation order in the case of Markandacharan Naik shows that he too was brought over to the work charge establishment in the post of work Sarkar, which is identical with that of the respondent. Full stop. The order further shows that Mr. Markandacharan Naik was allowed to continue till 31st March 2012. That is extending his retirement from 58 to 60 years. Paragraph. Since the respondent is identically placed as Mr. Naik, the learned single judge was right in allowing the writ petition filed by him by the impugned order and granting him the same relief. Paragraph. That view of the matter, the impugned order calls for no interference and the writ appeal is dismissed.
Obliged.
Item 99.
'99, my lordship can take up it to special list.
All right. That is your lordship. This is case, counter, rejoinder, everything is filed. There is no irregularity or illegality. 29 years he has served for the state.
We'll take it up with that.
Item number 100.
Well, I am appearing for the appellant, my lord. Well, here the appellant has challenged the order of the learned single judge.
My lord, in this case, my lord, on behalf of Mr. Das, my lord, appearing respondent number 4, my lord. Today I have received the agreement of file Vikalata number. Kindly take him next week, my lord.
Well, respondent number 4 is the main contesting party over here, my lord. He is the affected
Counsel
party.
appearing for respondent number 4 wants more time to respond. List on 31st August. What about the second sub-item?
Second sub-item, your lordship, it is similar to the first, your lordship.
All
It's similar to
list along with WA 1370 on 31st August.
Well, the interim order to continue.
Interim order.
your lordship. In second item, your lordship, there is no interim order. Similar order may be passed, your lordship.
Both cases, my lord, on behalf of Das,
Similar
respondent
order.
4, my lord.
Or in second item also you say there shall be a status
Item
quo.
number
Sir.
76.
What is the interim order? What is the interim order, sir?
Lordship, interim order is the order of the single order passed by the London single judge shall remain state.
Right. All right. The impugned order shall remain state till the next order. The second one.
Obliged, your lordship.
Along with your lordship, item number 76. Similar matter solution. Item 76.
So list along with on 31st August 76.
Pastor matter item number 4.
Number 4, Your Lordship. Your Lordship, as it's a writ appeal matter, Your Lordship, I need some time to prepare well, Your Lordship. Kindly keep it to next year.
What's the impugned order? March 24.
So kindly keep it to tomorrow. I'll prepare it.
All right. I have a request of counsel for the appellant list on 31st August.
Blessed Lordship.
Item number 6. Pastor matter item number 6.
Yes. None appears despite a password. Dismissed.
Item number 9.
None appears despite a password. Dismissed.
Specialist. Specialist. Item number 1, WA 234 of 2021 and dash.
This item number 1, a batch of cases.
Yes.
In fact, I've been engaged in this case for appearing for the opposite parties.
Yes.
In most of the cases, you also issued notice on limitation matters. I don't think that limitation is about 300 days. That's when
COVID period.
COVID period. That's right. That's
right.
So far the merit of the case also keep it to some other day so that I can file an affidavit because the list which has already been concluded, those documents, the judgments I'll produce before lordship by weapon affidavit. Government has implemented it. So I'll also keep it to some other day. And I had also.
Absolutely.
Yes.
No.
This is
I think he was making a distinction between cases which are covered by that Saraswati Boy, right?
Saraswati Boy, that's RSCP matter. This is the old pensions.
Old pension scheme.
The RSCP.
No, in this you are making a distinction between two.
Yes, Malad. In some, I'll give that, Malad, what has happened, Malad, in some cases, in that a similar writ application was here, Malad, that was dismissed. That went to the Honorable Apex Court. In that case, on 10th of April of this month, that notice has been issued and contempt proceeding has been stayed. I will give that.
In this case, in this particular case?
In similar type of case.
Similar type, I don't know. But the first round, give me a copy so that I can verify. In fact, it has been concluded by a division bench of this Honorable Court. They have implemented the judgments. So far, and your lordship have delivered a judgment in my case, that ratio also is applicable to this case. Because from the date of appointment initially against a sanction post, whether that period will be counted for the purpose of regularization or not, that is the only question. And they have regularized subsequently. There is no doubt about this. I'll verify this. What my learned friend says that he has gone to Supreme Court against which judgment, I don't know.
That Gitanjali Saptatin, that similar case, Dr. I used
1/12/2020 in Writ Petition Civil 14351 of 2019.
May I give that copy, my lord, object?
Yes.
Dita.
But in case of Udayanath Rao, had you?
No. Mupel in similar case, not in all cases.
Sorry.
This is all regularization, is it?
Yes, and consequential benefit from treating the regular from the date of their initial appointment and granting them to consequential benefits. So that if that regulation from 1994 and to enroll them under old pension rules. So our case before that, since he was on a contractual basis and on ad hoc basis, and he is entitled to all the benefits from the date of regulation, not prior to that. If we are extending all the benefits, then the regulation will be antedated from the date of his appointment. So that was our case.
No. So which cases are covered by this Supreme Court order?
I will give the list, my lord, so that my bunch of cases. Yesterday, I got the list at 12:30. So
I was not clear. No, so far as these cases are concerned.
I am clarifying. Well, three types of matters are there. One type of matter, doctors matter, the Ayush and homeopathic doctors. They are covered by the order I have given. And other cases, those who are contractual employees, subsequently regularized and brought to the regular establishment. Honorable Single Judge had directed to brought them under the old pension scheme, treating the contractual period as if service, and they have entered prior to 1/1/2005. Most of the cases are like this. My learned senior is appearing in those cases where they are initially appointed on contractual basis, subsequently regularized, that regular appointed prior to 1/1/2005, regularized after 1/1/2005. New pension scheme came after 1/1/2005. So they are claiming their appointment is prior to 1/1/2005. They are to be covered under old pension scheme. And the Honorable Single Judge had directed to cover them under old pension. Why they have done that? Our department has wrongly brought them to the old pension scheme, interpreting a letter issued by the finance department as if we have extended this benefit to the contractual employees. In fact, that letter was issued in favor of work charge employees, keeping in view Rule 18(6) of Odisha Pension Rules. That is sum total of the case, my lord. So it can be segregated in two parts. I'll give that list who will be covered by this Honorable Supreme Court case which is pending, and those who are the fresh matters.
All right. So in all these petitions, the question that arises is the consequential benefits that the respondent employee would be entitled to consequent upon regularization. Full stop. It is pointed out that in one set of cases where the employees, though contractual and regularized after 1/1/2006, were asked to be extended the benefit of the old pension scheme by treating the regularization as effective from the initial date of appointment, the matter has been taken by the state to the Supreme Court in SLP Civil number 4253 of 2021, in which an order was passed on 10th April 2023, directing notice to issue and contempt petitions to be stayed. Proceedings in contempt petitions to be stayed. Paragraph. In this entire batch of matters, there is yet another set of matters where the orders of regularization were passed prior to 1/1/2006.
1/1/2005, my lord.
1/1/2005. Right. That is when the OPS was still in force.
Yes, 1/1/2005 till 1/1/2005, Odisha pension rule was in force. After 1/1, new pension rules.
Yeah. Paragraph. Counsel for the state wants some more time to segregate within this batch the above two categories of cases. So which one do you appear in? You don't know.
I am appearing in WPC 867. Those matters, I think they have not gone to the Supreme Court. They have implemented. I am appearing in 867 of 2022. That is one of the cases. Of course, the others have come, but I have not appeared. 867. Arising out of the judgment of the Honorable Single Judge Justice Sadangi. That's the judgment. That is the second page. 95, 96, 97. Whatever. They
867. Fourth was the concept.
Who category Rashtriya Pradikhi?
That I'm from that, my lord, sir. Given that.
I think the first category which has been referred to.
Yes.
Yes. That means against one of such judgment, you have gone to Supreme Court.
No. That in that case, we have not gone.
They have not gone to
They are
Supreme
coming
Court in
in
my
that
case.
second category. Not under the challenge before the Supreme Court.
No. So their case regularization was prior to 1/1/2005.
Yes, after 1/1/2005. Regularization after 1/1/2005. Appointed under contractual basis before 1/1.
These are regularization prior to 1/1/2005. The Supreme Court order.
Yes, madam. No, so after 1/1/2005.
So they are covered with the Supreme Court order then?
Yes.
Mr. Khuntia, what my lord is saying, so far the Supreme Court matter is concerned, they have appointed prior to 2005 on contractual basis.
My lord is asking, they are regularized after 1/1/2005 or prior to 1/1 regularization.
We are concerned, we are regularized after 2005.
That I am, my lord is asking that
So
I am.
I think in those cases has been taken to the Supreme Court.
Yes.
Regularization happened after 1/1.
After 1/1/2000. That.
But my case,
yes. Not in your case, Supreme Court.
No, not in similar
In similar
case. I tell you.
Regularized after 1/1/2005, but the Honorable Division Bench in similar matter directed to brought them to the fold prior to the 1/1, treating the appointment from the date of initial appointment.
Yes. That means you have gone to Supreme Court in one of the identical cases.
So the other bunch of cases is those who are regularized prior to 1/1/2005, correct?
No, so all are regularized after 1/1/2005. All are appointed prior to 1/1/2005, regularized after 1/1/2005.
Right. That is all the cases.
All the cases.
So will not all the cases be covered by the Supreme Court order?
Yes, it can be covered, but in the one case, my learned senior is appearing that. So there we have not approved Honorable Apex Court. That's the first time it is coming before my lords. Lords, we can decide it.
I don't.
No. If it's pending in the Supreme Court, then why should we decide it? And then we'll only have to say we follow our own judgment. But since it's in state,
So my lord, Lordship, may urge it first.
All right. You say that is the matter. The entire batch is directed to be listed on 4th September. 4th September. Interim orders to continue. All right.
Item number 2.
In item 2,
What is this matter?
This batch of matters relates.
This order that I've passed, we'll just read it out once again. Just listen to it carefully. I don't want a mistake to happen. That
Right.
No, contractually employed prior to 1/1/2005 and regularized after 1/1/2005. Employed prior to 1/1/2005 and regularized after 1/1/2005. by treating them as regularized from the initial date of their appointment. The state government, the state government has approached the Supreme Court. All right, this is one. In the other category of, just next paragraph. Yeah, where the regularization took place prior to 1/1/2005, when the old pension scheme was applicable.
No. All cases regulation after 1/1/2005.
Then where is this two categories? Where are the two categories?
I take two categories. In earlier case, the honorable single division was directed to treat them as a regular employee with effect from the date of initial appointment. In all these cases, second category, the honorable single judge are not directed to treat them regular with effect from the date of their appointment, but directed to count their contractual service for the purpose of pension. That is the distinction, madam, in two sets of cases. Thereby, in that case, from the date of treat them regular from the date of appointment.
No. In the second category, they were appointed only after 1/1/2005.
Appointed on contractual basis prior to 1/1/2005, regularized after 1/1/2005. And honorable single judge are directed since they were appointed on contractual basis and regularized subsequently, that period will be treated as qualifying service and they will be enrolled under old pension scheme. Sorry, I could not convince my lord that.
No, because in both cases, they were appointed on contractual basis prior to 1/1/2005, regularized after 1/1/2005. Now, in one set of cases, they've been asked to be regularized from the initial date.
Yes.
In the second set of cases, without doing that,
yes,
they've said cover them under the OPS.
Yes, ma'am.
In the second set of cases, the learned single judge has, after noting that the employee was appointed on contractual basis prior to 1/1/2005 and regularized after 1/1/2005, directed that such employees should still be treated as covered under the OPS by treating the period of contractual service as qualifying service. All right. Okay.
Item number 2.
Item 2. This is regarding regularization of DLR employee. May I please, you will also take up this matter tomorrow so that I will classify into 3 categories. Matters which has been disposed upon the first day. I'll give that list and so that you will also can remind the matters to the honorable single judge for fresh adjudication. And some of the matters where counter has been filed and that has been disposed of, that can be segregated.
Would they not know?
Yes.
How many cases in the second batch?
133.
The file came to us late, so we tomorrow with the same heading it comes.
You've already made that list. Oh, he's already made that list.
In the supplemental list, some items like item 52, 54, 56.
It will be added to that item serial number.
Item number 2.
No, but you've already segregated. Oh, I see. In item 2 itself, there are first day disposals and the other which are after notice.
Yes, ma'am. So that it will be segregated, it can be disposed.
In my cases, my lordship, I am appearing in 7 cases. In my cases, my lordship, counter was filed and after taking into consideration the contentions made in the counter, disposal was made.
No, why don't we hear that matter where then that case, no point in sending back?
Yes, ma'am, it will be better, ma'am. You'll also fix one day, it will be better, ma'am. It will be better, ma'am. So that all the matters can be decided on merit, ma'am.
Lordship, in item number 2, there are sub-item 1 as well as sub-item 3, 4. I have instructions to appear in this case, Your Lordship. Your Lordship may fix up any other date next week or.
All right. In this item 2, There are two sets of cases in this batch. One where the writ petitions have been disposed of on the very first date of hearing without an opportunity to the state to file a counter affidavit. And the other batch where the writ petitions were disposed of after pleadings were completed. Paragraph. Since in any event, this court would have to deal with the merits of the petitions in the second batch, the better course is for the entire batch to be heard on merits by this division bench itself. Paragraph. Both parties want more time to prepare their submissions. Full stop. The state will file a comprehensive written note of submissions.
Yes.
Which will be common to all the matters before the next date. Full stop. As far as possible, the respondents should try and file a joint written note of submissions so that there is no repetition of arguments before the next date.
Milord, in item 2, Milord, one writ appeal number 28 of 22, Milord, that is with regard to data entry operator and is covered by your lordship's judgment. That is Patita Pavan Das case.
Which one?
Writ appeal number 28 of 2022. It is in item number 2.
Just take it out.
Tahsil. The petition is working as a DO under Tahsil, Milord. It's squarely covered by your lordship's judgment.
Which is this?
Writ appeal number 28 of 2022.
Yeah, all right. We'll just deal with it. The other matter.
And in this case, I have already entered my appearance and I filed the
1 minute. We'll just.
I am appealing for 3 appeals in item number 2, my lord. That order has already been complied with since 16/8/2022, my lord.
You have the implementation order.
Yes, my lord. I have filed so called appeal number 1099 of 2022 and 1103 of 2022.
1 minute, sir. So can we do it one by one? You do not mind. All the matters, we'll take up these matters separately. List on, because others need not wait. List on
1099.
1 minute, sir. We'll come to your matters in a minute. We are now dealing with all the other matters, sir.
1099.
List on 25th September. Interim orders to continue.
So far as
Writ appeal 28 of 2022.
Yes. Writ appeal 28 of 22.
You take it out. I don't know where it is.
Writ appeal 28 of 2022 covered by my lord's judgment.
Patita Pavan. So writ appeal 28 of 2022. It is agreed by counsel on both parties that the present writ appeal stands covered by the judgment dated dash of this court in writ appeal so and so Patita Pavan Pand. State of Orissa versus Patita Pavan. No, Patita Pavan Datta Dash versus State of Orissa. State of Orissa versus Patita Pavan Datta Dash. Accordingly, the writ appeal is dismissed. Now tell us here.
Next one is
the others need not wait. Others need not wait. Yes. Yes. What are your numbers, sir?
Another one is 1103 of 2022.
You gave us 4 numbers. You're giving us only 1 now.
3 numbers, my lord. 1099 of 2022. 1103.
1 minute. Just note down. 10.
10.
Start from the beginning, sir. Start from the beginning.
1103 of 2022 and 1104 of 2022. 3 numbers.
So start from the beginning. Give us the 3 numbers from the beginning.
1099 of 2022.
And then?
Then 1103 of 2022. Then 1104 04 of 2020.
Ha.
The 3 years have been already complied by the appellant since 16/8/2022, ma'am.
Where is that order?
My lord. That order has been accepted. I have annexed the order, ma'am.
Where is its copy?
It has been rejected, madam. As it appears from that has been rejected. Page 4 of that complaints.
Complaint is rejected, but order has been complied.
Order
Order has been complied. Then pending
Rejected, it says, sir. It says rejected.
Rejected, my lord, but order has been complied. That rejection order has been challenged and certainly order passed for implementation of order. Contempt has been filed and order has been passed. Thereafter, they have issued notice in appeal, my lord.
No, where is that order implementing? This is an order rejecting.
Rejected, my lord, but this order has been challenged in the appeal, my lord. The present order has been challenged. Order dated 11.
Sir, the present appeal is by the state.
My lord.
This is an order rejecting your representation.
Yes, my lord.
So how can state challenge this order?
No, my lord, the order of honorable single bench has been challenged.
By the state?
Yes, my lord. Prior to 16/8/2022.
Correct.
And in the meantime, appellants have complied with the order.
They have not complied, sir. They have rejected your representation.
Rejected, my lord. I have filed second writ petition challenging that rejection order. And stress direction has been issued. And as they have not complied with, we have filed contempt, my lord. Order has been passed and order has been communicated. Now the notice has been served on the respondent that the state has appealed the order dated which has been passed earlier, my lord.
May I clarify what he's saying? That against first order, we have rejected his case, and challenging the rejection order, he has filed another writ petition. Recording his submission, your lordship can dispose of the 3 writ appeals.
Okay. All right. It is pointed out that the order impugned in these 3 appeals, pursuant to the order impugned in these 3 appeals, the Health and Family Welfare Department, Government of Orissa, passed orders on 16th August 2022 rejecting the plea of the respondents for regularization of their services. Full stop. It is stated that the said order was again challenged in a fresh writ petition by each of the respondents herein, in which orders have been passed by the single judge. What the writ petitions are allowed again?
No, my lord. Fresh direction has been made as the matter is covered by another judgment of this honorable court and accordingly to comply with the order.
No. Where is the order in the fresh writ petition?
Fresh writ petition order appears.
Now I have not.
What does that order say?
Now the order is not with me.
No. What does it say? You don't even remember what that order says.
Order fresh direction has been made to consider the case of the petitioners as per the decision of this honorable court.
So that writ petition also disposed of?
No. That is pending now.
Pending. All right. Which is fresh writ petitions, which are stated to be pending before the learned single judge. Paragraph. In that view of the matter, the present writ appeals have been rendered infructuous and are disposed of as such. All right.
In item 2, my lord, serial number 2, writ appeal number 413 of 2022.
What is this? Yes.
In that case, the petitioner is the NMR worker praying for brought over to work charge establishment, not for regularization or regular establishment. And the similar matter has also been decided by the Learned Tribunal, confirmed by division bench of this Honorable Court as well as the Honorable Apex Court. Citing that judgment, the Honorable Single Bench has passed the order, and challenging that, the state has preferred this appeal.
So this must be similar to that other Saraswati boy.
No.
Work charge establishment.
No, that's
No, not is that. What is that? Markand something. Markand.
Markand and Naik. No,
Markand Naik.
That's a different issue.
No, he's also work charged.
So far as work charges are concerned, different type of cases are there. Some cases have been peaked to 14th September. And these work charge employees, they are seeking for regularization. This can be covered under item 2.
No, madam.
He says they're not asking for regularization.
I am asking for brought over to work charge establishment, madam. I am giving the copy.
347. What is the number?
414 of 414 of 22, madam.
414.
Basant Kumar Pradhan.
Yes, my lord. In that case, the prayer of the petitioner before the single bench was the similar such benefits have been extended only to brought over to work charge establishment as per the order of the Honorable Apex Court.
Your Lordship, page 14 is the input order. The very first
Prakash Nanda.
Yes, madam. Prakash Nanda case has been judgment passed by the Learned Tribunal, confirmed by division bench of this Honorable Court as well as Apex Court. My case is squarely covered with the Prakash Nanda.
No, but was it first day disposal?
That's the first day disposal.
This is the first day disposal.
That so let it go back.
Otherwise, my case is not regarding the entire batch of cases.
So if you're agreeable, it can go back.
It will go back.
Similar benefits have also been extended to the persons after the disposal.
No, if you are covered, then they'll be covered. Let them get a chance to examine your case.
Yes, sir.
The impugn order was passed on the very first day without any opportunity to the state. This is WA 414 of 2022. Without any opportunity to the state to file a reply. On that short ground, it is hereby set aside. And the writ petition civil 33471 of 2021 is restored to the file of the single judge in the roster bench, where it will be listed for hearing on 5th September. The state will file its parawise reply not later than 28th August. And the respondent writ petitioner will file any rejoinder, if any, on or before 5th September. Till then, you say the learned single judge is requested to proceed with the merits of the petition. No further time will be granted to either party for that purpose. The learned single judge is requested to proceed with the writ petition and dispose it off as expeditiously as possible.
Okay.
Maybe disposed. My lord, item 2, WA number 383 by 223. My matter is not a regularization matter. My job has been upgraded from NMR.
Give us the writ appeal number again, sir.
383 by 23.
23?
Again. Yes.
Sachidananda Mohanty.
My lord. This case is different. My job has been upgraded from NMR to work charge. And initially I was...
It is a different case, it can be segregated.
All right. This writ appeal 383 of 2023. List on 1st August. Interim order to continue.
My lord, in writ appeal number 347 of 2022, I am appearing on behalf of the respondent, and as per the instruction I have received, my client does not wish to contest this writ appeal. So,
oh,
347.
WA 347 of 2022.
State is the
Trilochan Malik.
He does not want to contest this writ appeal.
We are
all right.
Appellant.
Yeah, that's right. Counsel for the respondent states on instructions the respondent does not wish to contest the present writ appeal. That is the matter. The impugned order passed by the learned single judge is hereby set aside, and the writ appeal is allowed as prayed for.
His presence may be noted because he has not appeared for any Bhakalatnama.
My lord, I have filed the appearance memo and Bhakalatnama.
All right. All right.
Sometimes.
All right.
Supplementary list fresh admission item number 1, CRLMC 427 of 2020.
No, please.
Item number 2, CRLMC 437 of 2020.
Same order. Memo taken on record. Dismiss is not pressed.
Item number 3.
None appears dismissed.
Item number 4.
None appears dismissed.
Item number 5.
Same order.
My lord, I am the opposite party.
All right. None appears with petitioner. Right.
Item number 6.
None appears dismissed.
Item number 7.
Same. Memo taken record. Dismisses will go.
Item number 8.
Same.
Item number 9.
Yeah, please passing proceeding on the ground of this present case second rate to the annexure 4 mile. Because in same transaction already FR was lost, had annexure 4 mile, and in same covering same the transaction of present case already charges submitted had annexure 4 mile.
What are your instructions, sir?
Yes, my lord, we have received instruction.
Date of occurrence, place of occurrence, person victimized are different. Transactions are also.
No, my lord, kindly see my lord. So, page 64 my lord. Page 64, running page 64 my lord.
Point this out to the
same transaction was my lord, covering the present case my lord,
Already charge sheet submitted, my lord.
They don't agree with you, sir. So you can point out to the trial court. You say
But there is a judgment of appeals court, my lord.
additional standing
There is
counsel on
no second
instructions.
affair, my lord. There is a judgment of appeals court, my lord. In case of T.T. Anthony versus.
Point it out to the trial courts. Counsel, additional standing counsel of the state submits on instructions that in both cases, the date of occurrence, the place of occurrence, and persons victimized are different.
My lord, same
And the transactions are also different. Paragraph. However, this is contested by counsel of the petitioner. Paragraph. Since there is no agreement on the basic facts, it is not possible for this court to interfere at this stage. It will be open to the petitioner to point out, to raise all pleas at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated.
Item number 10.
None of is dismissed.
Item number 11.
None of is dismissed.
Item number 12.
Same one.
Item 13.
Item 13, may I please your lordship, my lord. So, my lord, there is a, my lord, both have already married in the meantime, my lord. And the affidavit, the opposite party number 2, which the complainant has filed an affidavit which is at black.
You are for the opposite party number 2?
My lord.
All right. Counsel for the opposite party number 2 confirms the affidavit filed by her, stating that they have both, she has married the petitioner and both are leading a happy conjugal life. That view of the matter takes in the prayer clause and all proceedings consequent thereto are hereby quashed.
Item number 14.
None appears dismissed.
Item 15.
Same order.
Item number 16.
May I please your lordship. Item 16, my lord, the order of cognizance dated 19th July 2019 is under challenge, my lord. In this matter, my lord, the charge sheet has been submitted under section 148, 147, 149, 341, 294, 506, my lord, of IPC.
But also SC/ST, sir. We are leaving that out. Also section 3 SC/ST Act.
There was no unlawful assembly. There was no
SC/ST Act, sir. You are leaving that out.
No, my lord, they are not, the petitioners are not implicated.
Just read the order taking cognizance. Come to page 24.
Lord.
Just show him the paper book. I think it's just, you don't seem to have your own paper book, sir. You don't have your own paper book. Kindly read from here what you have filed. This is the order taking cognizance. What does it say? Why don't you read the page showing? Why are you turning over the page? Why don't you read the page that you have shown you?
This on the record was put the order under section 147, 148, 341, 299, 323, 506, 149 of IPC read with section 3, clause 1 RS and 32 VASC and ST Act.
SC/ST Prevention of Atrocities Act. This is what I've been trying to tell you. You're not understanding. So cognizance is also additionally under this act. You have not read the case.
Millard, these two petitioners, they are not arrayed under this SC and ST Act, my lord.
Anyway, it's all right. Take the paper. Yes, permitting the petitioner to raise all pleas at the appropriate stage. Sir, next time when you come to the court, at least bring the paper book that you have filed in the court. You don't even have the paper book of the matter. How are you arguing matters? This is all very new experience. I have been a lawyer at the bar. I will not have the guts to go before a high court without my own paper book. I don't know. This is all very strange. Permitting the petitioner to raise all pleas at the appropriate stage. Petition is disposed.
Item 17.
None appears dismissed.
Item number 18.
My lord, in this matter, annexure 1, 2, and 3, the certified copies may kindly be.
Which matter?
In this item 16, my lord.
16, okay. The
replaced by
return subject to being substituted with attested photocopies. All right.
Item number 18.
None appears dismissed.
Item 19.
None appears dismissed.
Item number 20.
May I lordship, please? It is infectious, my lord.
Dismissed as infractious.
Item 21.
Kindly pass over on behalf of Mrs. Sena.
Item 22.
Permitted to withdraw with liberty to file a better application.
No. Just dismisses withdrawal. Yes.
Your lordship, I have not made a party for that reason. Liberty may can be given.
No. No liberty, sir. No liberty. Dismisses withdrawal.
Item 23.
None appears dismissed.
Item number 24.
None appears dismissed.
25.
Same order.
Item 26.
Item 26, let's speak only 1 week after allow for removal of the defect, my lord. In the Belgium, let's speak only, it's a Belgium matter. The NBW was issued, my lord, on dated 23/12/2015, my lord. By the annexure 1.
No stay granted, sir. By now it will all be over.
My lord, the petitioner was arrested 9/4/2014, my lord, and released on bail on 5/5/2014, my lord. Thereafter, the lacuna of the council, the petitioner's council, my lord, the petitioner council in appear, my lord. Thereafter, the NBW was issued, my lord.
Issued long ago, sir. NBW was issued in 2015. We are in 2023. Your client seems to be on a holiday. Yes. For 8 years, he has not surrendered, no? Last 8 years, he has not surrendered.
Not the instruction, take the
so meanwhile, you are taking adjournments. He has not surrendered for 8 years. You keep taking adjournments. Very convenient, sir.
Instruction, my lord.
No need for instruction.
Kindly permitted to withdraw, my lord.
Dismissed as withdrawn.
Yes, my lord.
Item number 27.
What she say?
Not pressed.
Not pressed. Dismissed as not pressed.
Item 28.
None appears dismissed.
Item number 29.
Same order.
Item number 30.
Same order.
Item 31.
Not pressed. Dismissed as not pressed.
Item number 32.
None appears dismissed.
Item 33.
My lords, here a protection of women from domestic violence case has been instituted against the husband by the wife, though both of them are residing together. And before cognizance, my lords, without complying with section 23, an interim order has been passed. Dears all this, my lords, the parties have now decided to settle, but because the opposite party's counsel's name has not appeared today, my lord, she has not appeared. Your lord, you may call it some other week.
What is the name?
No.
What is the name of the counsel?
I think Mr. Ramesh Agarwal and his wife have appeared.
But notice never went to this petition.
No, they have appeared, my lords.
I see. Yeah, notice is gone. Okay. It is stated that Mr. Ramesh Agarwal has been appearing for opposite party. His name be reflected in the cause list. List before the roster bench. On 11 July, interim order to continue.
Item 34.
None appears dismissed.
Pardon, my lord, item 18 next week, my lord. Unfortunately, I have not come due to scooter problem.
Tell us.
Next week, my lord.
No. What for what?
Suddenly listed, my lord.
Nothing sudden, sir. No sudden. Tell us what the matter is about.
And not doctor to my lord.
No, we'll permit you to raise all pleas, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. All right.
Item number 35,
None of is dismissed.
36,
Same order.
item 37,
37, my lord. 37. I am appearing for the petitioner. Here, my lord, there is a dispute between the husband and wife with the petitioner and his wife. Petitioner is the brother-in-law and the wife is the sister-in-law. They have no way connected with the allegation. So only prayer for to quash the proceeding against me, against us. I can understand. Suppose there is a dispute between the wife can make any sorts of allegation against the husband. We don't have any dispute, but only to drag to the court because we are not staying with my brother. We are staying separately. He is a practicing advocate residing at Banki, sir. Sir.
So he pointed out, permitting the petitioner to raise all pleas at the appropriate stage. Petition is disposed. All right.
Next also same. Is the father-in-law and mother-in-law. Same. 38.
All right.
Much obliged, sir.
item 39,
None of is dismissed.
item number 40,
Same order.
item 41,
Item 41 on behalf of Mr. M.K. Mahapatra, Lord, no instructions
No
with
instruction
liberty may,
dismissed. All right.
Lord, liberty may be given to
No
this.
liberty, sir. Yes.
item 42,
None of is dismissed.
43,
Same order.
item number 44, 43, man.
43. No instruction, Lord.
No instruction dismissed.
item 44,
None of is dismissed.
item number 45,
Same order.
item 46,
Same order.
47,
Same order.
48,
Same order.
item number 49,
Same order.
item number 50,
May I please, Your Lord? My lord, the company is not a party. Check bounce case, Your Lordship.
All right.
Annexure 3, page 15 is the check issued, Your Lordship.
This has been issued by TK Marines Private Limited, which has not been made a party in the complaint. No, it has been made a party.
No, my lord.
Oh, right. However, only the petitioner who happens to be the managing director has been made accused. In view of the judgment of the Supreme Court in Anita Hada versus Godfather Travels. The order dated 21st November 2019 passed by the SDJ Bhubaneswar in 1CC case number 4551 of 2019 and all proceedings consequent thereto are hereby quashed.
item number 51,
None appears dismissed.
item number 52,
None appears dismissed.
item 53,
My lord, petitions have raised all the points before the trial court.
Permitting the petitioner.
okay. Item 54,
None appears dismissed.
item 55,
None appears dismissed.
56,
Same order.
item 57,
Same order.
item number 58,
Same order.
item 59,
My lord, not pressed, my lord.
Dismisses not pressed.
item number 60,
None appears dismissed.
61,
May I please, Your Lordship?
Yes.
Bishop, the petitioner may be permitted to raise all these points before the learned trial court.
All right. Permitting the petitioner raise.
Much obliged.
item number 62,
None appears dismissed.
63,
Same order.
item number 64,
Same order.
65,
My lord, item 65 is infructuous.
Dismissed as infractions.
item 66,
None appears dismissed.
item 67,
Same order.
68,
68, I'm in VC, my lord. Here what has
Yes.
happened. FIR was lodged in 2003 under the Prevention of Corruption Act, and in 2006, final report was given against this present petitioner and 3 other accused, my lord. And in 2011, the Vigilance Court at Cuttack held that sanction is required. And thereafter, in 2019, the matter was transferred to the Angul Vigilance Court, where the occurrence had taken place. Now, before the Angul Court, before taking of the cognizance, summons were issued to this present petitioner and the other three accused, my lord. The other two accused have already approached this honorable court, and by CRLMC number 1450 of 2019, the proceeding has been quashed because due to non-taking of cognizance, the summons could not have been issued. That order was passed on 15/5/2020. I am in the similar footing. I am one of the accused in the same FIR, which was quashed by, as far as the other accused persons are concerned.
Where is that order?
It's with me. Can it come next to tomorrow? I can just place it, my lord.
At the request of Mr. Acharya and Senior Counsel to Petitioner. Let's go for the roster bench. On 9th May.
Obliged, my lord. Grateful.
Item number 69.
None appears dismissed.
Item number 70.
None appears dismissed.
71.
Same order.
Item 72.
Same order.
Item 73.
Same order.
Item number 74.
Memo taken on record. Dismissed is withdrawn.
Item 75.
None appears dismissed.
Item number 76.
Record my name as opposite party, my lord. So I'm there.
75 to
75.
Yeah.
Grateful.
Item 76.
Raise all the point in the trial court.
All right. Permitting the petitioner to raise all, please.
Item 77.
Permitted to withdraw with liberty.
Dismissed is withdrawn.
To raise all the points code.
Then you say permitting the petitioner to raise all, please. All right.
Item 78.
May I please, your lordship. Lord, your lordship is by the order dated 12th November 2020. Please to direct that produce all documents and stay the NBW, your lordships. There is a case, my lord, for the same proceeding on FIR. There is a when the investigation going on and trial is going on, my lord, for same cause of action, my lord, 1cc complaint case filed, and without compliance of 210 section 210 of the CRPC, the NBW was issued. And this proceeding was challenged. Your lordship can have ordered it 12th November 2020. Your lordship.
Yes, yes.
Your lordship has
What are
pleased
your
to-
instructions?
Instruction has not been received.
It's only against NBW order, sir.
And there is a 210. The my lord specifically state that when there is a procedure to be followed, where there is a complaint case and police investigation in respect of same offense, your lordship.
All right. Counsel for the state needs more time for instructions. Interim order to continue. Please book the roster bench on 27 June.
Obliged.
Item number 79.
Permitted to withdraw with liberty.
Dismissed. Permitting to, yeah, permit to raise all, please. In the proposed.
Item number 80.
Memo taken on record. Dismissed.
80, I am for opposite party, my lord.
All right.
Passed door matter. Item number 21.
On behalf of Mrs. Jenna Miller, I mean, this 482 petition has been filed challenging an order taking cognizance under sections 498A, 294, 506/34 IPC, and 4 of the DP Act.
Yes.
The marriage has been declared as null and void by the competent court, milords.
I see.
So therefore, no proceedings can lie,
Where is
milords.
that? Where is that order?
The copy of the judgment, milords, of the family court, milords.
Mr. Devashish Pandal and counsel petitioner produces a copy of the judgment dated 26 July 2021 passed by the Family Court Cuttack in civil proceeding number 145 of 2018, holding the marriage between the petitioner and opposite party number, petition number 1 and opposite party number 2 to be null and void. What about the service of notice? Addressee long time absent out of station. That's the remark, sir.
Opposite party too.
Yes.
She is not appearing anywhere.
No, but service has to be effected anyway.
The state.
Hmm?
Looking the state to intimate on the through police station.
What is you have to intimate the service of notice through the police station.
Yesterday also I contacted with the concerned IIC, my lord. The concerned IIC told me that she is taking step for service of the notice, my lord.
Council of the state needs more time to effect service of notice through the IIC concerned on the opposite party number 2. Fresh notice by that method, by that mode, returned for the roster bench on 25th July. Interim order.
Interim order.
Challenge that a common order passed by this honorable court. In a similar matter, my lord, another appeal of the state has been dismissed. I've given a copy of the lordship's order, my lord. A common order was passed. We had challenged that in appeal, my lord. In another appeal, lordship has been pleased to pass this order.
So the 64, where is 64? Take it out.
My lord, WA 964. The lordship has been pleased to adjourn this case.
We should simply say dismissed in view of the judgment.
My lord.
All right, in view of the judgment dated 15th February 2023 in writ appeal number 936 of 2021. Bracket Principal Secretary to the Government School and Mass Education Department. This is Niranjan Das. The present appeal is dismissed.
Matter fixed for court. Item number 89.
89.
Lordship, you can see the order dated 23/2023. My lord, 5 directions are issued by my lords. Your lordship, you can see paragraph 2 first. There, my lord directed that Mr. So-and-so and additional government of further the adequate funds have not been released by the government of India for the rehabilitation work to be undertaken by the department. However, it is seen that the details given in para 6 of the affidavit do not indicate what is the amount actually sanctioned and in relation to it, what percentage of the amount was utilized. Mr. Mudulil and AGA state that better affidavit will be filed giving the, I have filed this affidavit at flag 52. Paragraph 3. May I place one? Paragraph 3, internal page 3, that it is pertinent to mention here that Government of India does not sanction fund against each activity or component of the NLEP. Fund is sanctioned for each program as one pool fund, which is to be spent based on the approved budget against each activity. So it is not possible to provide the activity component-wise sanctioned amount under NLEP. Similarly, Government of India does not release the funds activity-wise under NLEP. Rather, it is released as a common pool fund. So it is not possible to provide the activity component-wise fund released under NLEP. In the years, the percentage of expenditure is below expectation due to clubbing and deferment of LCDC campaign and other activities due to pandemic. In all those years, there is no compromise in the treatment and training aspects of the NLEP program. In the year 2023, the provisional expenditure is 1996%. Now, my lord, you can see same affidavit and page 5. Page 5, that is relating to the year 2013-14. You can see column 2. These are the activities under the NLEP. Then column 3, amount approved by the Government of India. Now, you can see last total is 707.03 lakhs. Now, against that, you may kindly turn column 5.
So now it's again gone up after dipping to 43% during COVID time. It's according to you, it's now gone up to 96%.
Yes.
There's no way of verifying this. We just have to go by what you say. All right.
And so far as the next direction is concerned at paragraph 3 of the order, they are, my lord, directed to supply the electricity to all those 8 houses which have been constructed and to alert them to the respective, that I have filed the affidavit that is at flag 53. That is the affidavit by the on behalf of the collector Baleswar, paragraph 2. May I place one?
The electricity connection has been provided.
And so far as the power loom is concerned, that I have explained in paragraph 3. Because for the training purpose that was hired, and after completion of the training, it has been returned from the person from whom all those machines were hired. Now, after receipt of the applications for permanent on allotment on permanent basis, we are processing that, and we have stated that about 6 months we will allot the new ones. And so far as reconstruction surgery is concerned, in Baleswar there is only one case, and that has been completed in paragraph 4, we have stated. Then the other direction is at paragraph 4 of my lord's order.
All right. One person, you've done it.
Yes. So far as Baleswar district is concerned. Then so far as reconstructive surgery is concerned, no, rehabilitation in Sanjay leprosy colony, that my lord directed in paragraph 4. Now I have filed the affidavit that is at flag 51. That is on behalf of the collector Puri, paragraph 2. That as per instruction of government communicated by letter dated
this last week of this April month, you're going to provide shoes. That's what you say. The organization is assured to supply the shoes during the last week of the current month.
Yes, and that is relating to shoes. But so for the other rehabilitation, paragraph 2, we have stated, so for the balance 8 families are concerned. Construction of EWS houses are to be constructed within the premises of Niladri Rehabilitation and the Puri Municipality in respect of Sanjay Ji College, Station Road, through the Superintending Engineer R&B Puri. As per district of a letter dated 2/1/2023, the Superintending Engineer by letter dated 17/3/2023 has submitted a rough estimate for construction of the 10 residential unit with an estimated cost of 1,19,01,500. Copy of estimate has been submitted to government in SSCPT department.
No, so it's still stuck in the government.
Yes, it is now. Your Lordship has to intervene so that they can approve all these funds so that it can proceed. Construction can proceed.
No, it's up to you, sir. Now it's all with you only.
Yes.
Government in the Health and Family Welfare Department, you seem to have got it on 15th April.
Yes. And so far as the monitoring committee meeting is concerned, that has also been held last Saturday, that is on 22/4/2023. And today I have filed the copy of the affidavit, though it was filed yesterday by e-filing. Hard copy today I am filing. There, my lord, Annexure B. That the entire proceeding. And my lord senior Mr. Tripathi as well as Ms. Ratha also appeared in the meeting, participated in the meeting.
So when we say backlog of reconstructive surgery, how many such cases are there and what is the plan for that?
And that is there, that statement you will see page 8. Page 8 of the same affidavit.
179 cases. No, what has been conducted?
No, conducted is a total case.
97 is pending.
Yes, 97. Why it is pending? You will say the
21 are medically unfit.
Yes.
15 are in Almilling, 17 are migrated.
And 17 cases have migrated to other places.
So just tell me what do we further need to do? I mean, this covers the Puri, this Niladri areas in Puri.
Yes, of course, we had raised the concerns there. That time, this information was not there. It only comes right now that it seems that they have done so. But we will be visiting Puri, that place. We'll do that.
Right.
That's one thing. But the second thing is that again in the agenda, the meeting, there was no agenda, but we raised concerns about other centers. So those things are nothing is coming up. So because the whole idea was Baleswar to be replicated everywhere.
Correct.
So that is not happening.
Baleswar is all right now?
Baleswar.
Except that weaving unit, which they have said that they'll complete it within 6 months. Otherwise, Baleswar is on track, but so far as the other districts, in fact, my friends, they attend the meeting. They was like, I was also feeling that if Mr. Ishwar Mahanti can be brought from the government side, then getting them to implement these orders may be easier. He's
my learned senior Mr. Tripathi is also additional government advocate.
He is
can
a part of our group.
He can assist both ways.
He has to wear both hats.
Yes.
Your Lordship, may kindly see order number 27. We had identified, my lord, lots of 13 colonies order number 27, 23 to 2022. Lords may kindly see paragraph 4. We had identified 13 colonies in the state of Odisha, my lord, where at the first phase, my lord, the direction was to take up all those livelihood programs. And we had referred to those 2 guidelines of the state government, my lord, that to be implemented in all those areas.
Right.
Actually, my lord, we have not been able to visit all those 13
colonies.
I was just requesting my 2 friends that maybe we'll visit and place a report for lordship so that.
Because I think one is at Bargad.
My lord.
Well, in fact, pursuant to that order dated, order number 27 dated 23 to 2022, I have filed compliance affidavit of all persons concerned. I have filed compliance affidavit pursuant to order dated 23 to 2022.
The present condition of those colonies and how the skill development programs are going on, let's say a little bit of monitoring is required, certainly.
Where is your affidavit? Which one?
On 23, it was filed in the month of May 2022. And I don't have the flag numbers.
Chief Secretary. Additional Chief Secretary.
Yes.
Correct. That's it. 13th May 22.
Yes. The detail we have provided.
So let them visit if they can. Because there are there's Jharsuguda, there's Bargad, Sundargarh. I think maybe Rourkela, right? Yeah, Rourkela is in Sundargarh. Correct. All right.
Pursuant to my lord's order, the convener of the monitoring committee is also present by BC mode.
All right.
May I be permitted to repeat our prayer, Your Lordships? What happened if Mr. Ishwar Mahanti is there? There is one thing, what is happening is a little communication gap is happening. Because then, for example, then they come and then they report the government council and then things come up. So we'll be in one mind, and if he's there, and then what is transpiring. Like, for example, last time, Your Lordships, the only matter which got discussed is this Puri and this surgery. When we asked about the other colonies, they said it is not there in their agenda. So these kind of, there's a wastage of time otherwise. Because every colony needs a continuous monitoring.
Right.
So that is why.
To that, my suggestion will be, my Lord Senior Mr. Tripathi is quite senior to me as well as to Mr. Mahanti also. He can handle both the sides.
Mr. Tripathi probably in that role he is not here. So that's why
No, he can ask because he's quite senior.
Our reason
as a government counsel, also as an advocate.
No. Well, there's no conflict. Mr. Tripathi continues to be with us. We also need to have younger members. We need younger legs. He's somebody
because this is something not going to end. I mean,
no, certainly not. The idea is to keep it monitoring so that.
Yes.
All right. You see, in compliance with the order passed by this court on 20th March 2023, in compliance with the directions issued by this court in its order dated 20th March 2023, affidavits have been filed on behalf of the state reporting affidavits have been, 3 affidavits have been filed by the state. So
4 affidavits.
4, is it?
Yes. 2 collectors. One is of the health department as well as one of the
4
SSCPD department. Flag 51, 52, 53, and the hard copy we have
Right.
filed.
As regards utilization of funds in the affidavit dated 19th April 2023, it is stated that the funds are released by the central government under the National Literacy Eradication Program in a common pool fund from where monies are utilized for specific activities. So, enclosed with this affidavit are charts showing the utilization of funds from the year 2013-14 onwards. Full stop. It is now stated that for the year 22-2023, the utilization is 96% of the funds available with the state government. On the question of the inmates of Louis Leprosy Colony, Baripada, being provided the 8 quarters and electricity connections. The affidavit dated 20th April 2023 of the District Social Security Officer, Baleshwar, has reported compliance. Full stop. As regards providing of permanent looms, it is assured that within 6 months' time, they will be provided to the inmates. Stop. One inmate who required reconstructive surgery was successfully operated upon and discharged on 10th April 2013. Paragraph. The District Social Security Officer, Puri, has stated in the affidavit dated 17th April 2023 that ten residential units are proposed to be constructed within the premises of the Niladri Nilaya Rehabilitation Center for the Sanjay Ji Colony inmates at an estimated cost of around 1.19 crores. So the proposal is now sent to the government on 15th April 2023. Mr. Mudaliar assures the court that this proposal will be cleared at the earliest so that the construction work can begin within a period of 3 months from today. Full stop. As regards providing shoes of grades 1 and 2, a survey was conducted in both the Jibaramji Palli and Sanjay Ji colonies, and 99 beneficiaries were found eligible. Full stop. It is expected that the CRSR will be providing the shoes by the end of April 2023. Paragraph. Another affidavit dated 24th April 2023 of the Additional Secretary to the Government, Social Security and Empowerment of Persons with Disabilities has been handed over in court, explaining, giving details of the reconstructive surgeries performed in 27 districts Full stop. The figure of 97 such surgeries pending has been explained as owing to 59 persons being unwilling for surgery, 21 being medically unfit, and 17 having migrated to other places. Paragraph. Mr. Tripathi learned amicus curiae suggests that of the 13 colonies for persons with leprosy set up all over the state, reliable information regarding the condition in some of the colonies is not available. And the amicus curiae amongst themselves will chalk out a plan for visiting some of the colonies at Rourkela, Jharsuguda, and Bargarh and submit reports to this court before the next date. Paragraph. The court has also perused the minutes of the 5th meeting of the monitoring committee held on 22nd April 2023, where some of the measures still required to be undertaken by the state government have been discussed. First of the court expects the next meeting of the monitoring committee to be held within a period of 2 months from today. Why did you ask Mr. Ishwar Mahanti to be part of it? It only strengthen their hands.
Yes.
You see, the court.
Because Mr. Tripathi, my learned senior, well, he has a command over the officers.
No.
He's quite senior.
No. My lord, may I include him so that Mr. Mahanti also learns from Mr. Tripathi.
All right.
Maybe under the guidance of Mr. Mudali also.
In terms of the requests made by the 3 ACs, amicus curiae, in this court, the state government is requested to spare the services of Mr. Ishwar Mahanti, Additional Standing Counsel, to also attend the meetings of the monitoring committee, so that the implementation of so that there is no communication gap as regards the implementation of the orders of this court passed from time to time in these cases. (25th July). 25th July.
Appearance of the convener of the monitoring committee.
Yes. Who's also present online, you can say, and we refer to the affidavit. All right.
Deep.
One more is there, is it? Mine, is it? You mentioned this morning.
My lord, I'm through VC, lordship.
All right.
Lordship, this is a.
All right. Counsel, the petitioner mentioned this case this morning, pointing out that the daughter of the petitioner has expired yesterday.
Yes, my lord. Yesterday evening. And
Yesterday
from 16th of this month. Shivaji Hospital.
What about the state council? Who appears for the state here? Where are you located? Mr. Manohar, where are you located?
Right now, my lord, I'm in Delhi.
In Delhi?
Yes, my lord.
No, who's appearing for the state? Because otherwise the order will not get implemented.
But on the same date, the medical condition was so worse that I had apprised the Honorable Court that she may die. But Honorable Court was not of the view that she may die or not die. I am not concerned at all.
No, but is the death certificate there or?
No, my lord, death certificate has not been issued. But I have annexed the photo of his death. It's on the PDF page number, Lordship, PDF page number 10. Picture just taken after death. And also on the page number 9, my lord can see the certificate of referral. On 19th of April, the condition become very worst. So on that very day in the afternoon, I mentioned the matter was fixed for next day hearing. But on that day, Honorable Justice told me that it is not.
No, 1 minute. We don't have to go through all that again. Just show me the affidavit you filed saying that she has died. Which is that?
This IA was filed on the.
No. Show me the affidavit where you say that she has died.
Not just I am apprising. This IA I had filed on the 20th, and death has occurred on just a day ago.
No, but you should file an affidavit. How do we take a fact on record?
Lord, I am appearing. If your lordship can take my statement on record.
No, can't be like this, sir. There must be some affidavit of a responsible person. It can't be just a lawyer making a statement.
I will file. I'll file right now. I can file.
No, but then the state council also has to be there.
Had I been there physically, I would have filed in the morning itself. Lordship. Problem is this that it's emergent condition, so some.
No, but your wife is there, right?
Yes, wife is there. Wife is
it's
there.
all right. I mean, in the sense that she can take care of all that needs to be done in the hospital.
No. The last.
I'm sure there are other relatives too.
My lord, I can also humbly submit that after the death of this daughter, wife is also on the bed, seriously ill.
No, it's all right. I'm just saying there must be some other relatives, somebody to take care of these requirements.
My lord,
you have to file. See, the problem, sir, you have to file some affidavit, some further application. Something has to be in court's record. It can't be just your statement. You're not realizing the seriousness of this. You see, after all, the person is in custody, you're asking for interim bail. There has to be at least an application with an affidavit. I can at the best say it will be listed at 10:30 tomorrow morning. All right. It will be taken up as the first case tomorrow. All right. You better keep ready your affidavit and application. All right.
I'm obliged.
So you don't need to pass an order then. Just make sure that, because already a date fixes tomorrow. You make sure that the affidavit is on records by tomorrow morning.
My lord, the matter will be heard in this court or in the
No. It will be heard in the court where it is already listed. All right.